11:30 and noon. Even though it's noticed for 10:30, I think the time for opening statements will burn up the time between now and 10:30 so we can get to the witnesses. I would like to welcome everyone to today's hearing on the Judiciary Committee's Overcriminalization Task Force. The 10th and final hearing will focus on the abundance of federal criminal offenses on the books and the role that the Judiciary Committee's jurisdiction or lack thereof under House rules plays on this issue. Over the past year, the task force has examined many important topics in this area, gained valuable perspective on the issues from a number of highly qualified witnesses, two of which rejoin us today for today's hearing. I anticipate that they will be able to provide this body with meaningful insight into the subject of today's hearing, and I appreciate their continued cooperation in the furtherance of the goals of the task force. Despite the fact that it is generally accepted that the federal government does not possess a general police power, recent studies have concluded that the number of federal criminal offenses on the books has grown from less than 20, which were directly related to the operation of the federal government in the years following this nation's founding, to nearly 5,000 today, which cover many types of conduct undoubtedly intended by the framers to be left to the individual states. At the current rate, the Congress passes an average of over 500 new crimes every decade. This surge is highlighted by a particularly telling statistic. Nearly 50% of the federal criminal provisions enacted since the Civil War have been enacted since 1970. The sheer number of federal crimes leads to a number of concerns. Issues of notice and fairness, where legal practitioners, not to mention the general public, have difficulty in determining if certain conduct violates federal law, and if so, under which statute. The disorganization, decentralization, and duplicative nature of the federal collection of criminal laws needs to be addressed. I have introduced legislation to do just that in the Criminal Code Modernization and Simplification Act. This bill would cut more than a third of the existing criminal code, reorganize the code to make it more user-friendly, then consolidate criminal offenses from other titles so that Title 18 includes all major criminal provisions. There are likely a number of reasons for this rapid expansion of federal criminal law, including the fact that many criminal statutes are drafted hurriedly in response to pressure from the media or the public, and as a result, often duplicate offenses already on the books and omit critical elements such as a valid mens rea or a criminal intent. Additionally, under the current interpretation of the House rules, it is possible and not uncommon for new criminal legislation to make its way to the House floor without ever receiving proper scrutiny from the Judiciary Committee. This committee is comprised of lawmakers and professional staff with expertise in drafting criminal provisions and the ability to avoid redundancy through situational awareness of the entire body of federal criminal law. As we move toward wrapping up the business of the task force, in addition to other potential recommendations, we should consider pursuing an amendment to the rules clarifying the jurisdiction of the committee with respect not only to criminal law enforcement, but criminalization and criminal offense legislation as well. Again, I would like to thank our witnesses for appearing today, and would also like to thank the members of the task force for their service over the past year. In the coming months, I hope we can begin to come together to address many of the concerns with overcriminalization that have been identified. Before introducing Mr. Scott for his opening statement, I would like to ask unanimous consent to include for the record, a memorandum dated July 21st, 2014 from the Office of the House Parliamentarian, and a CRS report entitled Subject Updated Criminal Offenses Enacted from 2008 to 2013, dated July 7th, 2014, into the record. And without objection, it is so ordered. And it is now my pleasure to introduce the gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Mr. Chairman, we created this task force in recognition of the need to address the explosive growth of the federal prison population and the dramatic expansion of the U.S. criminal code. For 5 decades, Congress has increasingly addressed societal problems by adding a criminal provision to the federal code. Too often, we've done this in a knee-jerk fashion, charging ahead with the same failed, tough-on-crime policy and addressing the crime of the day instead of legislating thoughtfully and with the benefit of evidence-based research. When it comes to criminal law, only those matters that cannot be handled by the states need to be addressed by the federal government. What valid purpose is served by creating crimes at the federal level if they duplicate crimes being effectively enforced by the states? For example, why should there be a federal carjacking statute? State and local law enforcement have investigated and prosecuted carjacking effectively for years, long before Congress made it a federal crime. 2 weeks ago, in testimony before this task force, Judge Irene Kelly reminded us of the following recommendations made by the Judicial Conference in 1995 regarding 5 types of criminal offenses it deemed appropriate for federal jurisdiction. Offenses against the federal government or its inherent interest, criminal activity with substantial multi-state or international aspects, criminal activity involving complex commercial or institutional enterprises most effectively prosecuted using federal resources or expertise, serious, high-level, widespread state or local corruption, and criminal cases raising highly sensitive issues. We've ignored these recommendations. Earlier this month, the Congressional Research Service of the Library of Congress informed us that 403 criminal provisions were added to the U.S. Code between 2008 and 2013 for an average of 67 new crimes a year. Of those 403 new provisions, 39 were not even referred to the Judiciary Committee. For the past several years, we've estimated that there were 4,500 federal crimes. Now the new estimate from CRS is approximately 5,000. In addition to the 5,000 crimes in the U.S. Code, there are approximately 300,000 federal regulations that are enforced with criminal penalties. Several witnesses at our hearings have testified that many of the regulations lack an adequate criminal intent or mens rea requirement to protect those who do not intend to commit wrongful or criminal acts from prosecution. Witnesses have suggested the enactment of a default mens rea as well as legislating the rule of lenity for statutory construction as an appropriate fix for existing statutes and regulations. We've also heard concerns about federal agencies' promulgation of regulations that carry criminal sanctions. It's time for Congress to put an end to that practice, reclaim that authority, and retain sole discretion in determining which actions are criminal and what sanctions are appropriate when deprivation of one's liberty is at stake. Regulations can still be enforced with civil penalties, but when criminal penalties are considered, Congress should be involved. The result of decades of criminalizing more and more activities has been the growth of the federal prison population from about 25,000 in 1980 to over 200,000 today, making the United States the world's leader in incarceration, about 7 times the international average. The Pew Center on the States estimates for any incarceration rate over 350 per 100,000, the crime reduction value begins to diminish because at that point you certainly have all the dangerous people locked up. We've also learned from the collateral consequences that more than 65 million Americans are now stigmatized by the criminal convictions, bombarded by over 45,000 collateral consequences of those convictions, making reentry and job prospects dim. And in spite of this research that over 350 per 100,000 population yields diminishing returns, and the Pew Research Center also said that anything over 500 per 100,000 is actually counterproductive, the United States leads the world at over 700 per 100,000. That's because unnecessarily locking up people wastes money that could be put to better use. Families are disrupted, making the next generation more likely to commit crimes. Over 700 per 100,000 counterproductive, and we lock up well over 700 per 100,000. 500 per 100,000 counterproductive. We lock up over 700. The testimony received during these hearings has consistently told us that longer sentences are not the answer, yet we continue to create more crimes, increase sentences, and add more mandatory minimums. Mandatory minimums have specifically been studied extensively and have been shown to disrupt rational sentencing patterns, discriminate against minorities, waste the taxpayers' money, do nothing to reduce crime, and often require judges to impose sentences that violate common sense. A code is defined as a systematic and comprehensive compilation of laws, rules, regulations that are consolidated and classified according to subject matter. Our criminal code is not a criminal code by that definition. Its federal criminal offenses are spread all over the 51 titles of the U.S. Code, making it virtually impossible for practitioners, not to mention an ordinary citizen, to make any sense out of it. It's time not only to move all criminal provisions into one title, Title 18, but to also clean up and revise it as recommended by witnesses in previous task force hearings. We need to consider how to proceed, whether this should be, and we also need how to proceed and whether or not this should be done by Congress itself or by an appointed commission. It's time that we consider evidence-based research and make wiser policies in our sentencing policy. We're wasting billions of dollars in crime policy that has been failing for the past 4 decades. It's time we look for a more realistic and reasoned approach to the issue of incarceration, understanding that not every offense requires a long sentence of incarceration. Mr. Chairman, while this is the final task force hearing, there's still much more to do, and I look forward to working with you in drafting a consensus report, presenting it to the full committee, and taking the necessary actions to improve our criminal justice system.
The time of the gentleman has expired. Without objection, all members' opening statements will be placed in the record at this point. It is now my pleasure to introduce the witnesses. First is Dr. John S. Baker, Jr., who is the visiting professor at Georgetown Law School, a visiting fellow at Oriel College, University of Oxford, and emeritus professor of law at the LSU Law School. He also teaches short courses on the separation of powers for the Federalist Society with Supreme Court Justice Antonin Scalia. Dr. Baker previously worked as a federal court clerk and an assistant district attorney in New Orleans and has served as a consultant to the U.S. Department of Justice, the U.S. Senate Judiciary Subcommittee on Separation of Powers, the White House Office of Planning, USIA, and USAID. He was a Fulbright Scholar in the Philippines and a Fulbright Specialist in Chile. Dr. Baker served as law clerk in Federal District Court and as assistant district attorney in New Orleans before joining LSU in 1975. While a professor, he has been a consultant of the State Department and the Justice Department. He has served on the ABA task force, which issued the report, The Federalization of Crime. He received his Bachelor of Arts degree from the University of Dallas, his J.D. from the University of Michigan Law School, and his Ph.D. in political thought from the University of London. Mr. Stephen D. Benjamin is the president of the National Association of Criminal Defense Lawyers. The NACDL is a professional bar association founded in 1958. Its members include private criminal defense lawyers, public defenders, active-duty U.S. military defense counsel, law professors, and judges committed to preserving fairness within America's criminal justice system. He is in private practice at the Virginia firm of Benjamin and DePort. DePort?
Yes, Ports.
Okay. He serves as special counsel to the Virginia Senate Courts of Justice Committee and is a member of the Virginia Board of Forensic Science and Virginia Indigent Defense Commission. He previously served as president of the Virginia Association of Criminal Defense Lawyers. I would like to ask each of you to confine your remarks to 5 minutes. You know what the red, yellow, and green lights mean. Without objection, your full written statements will be placed in the record, and Dr. Baker, you're first.
Thank you, Mr. Chairman, Mr. Ranking Member, and members of Congress. I've testified here twice before, and I appreciate
Push.
I've testified here twice before, and I thank the committee for task force for allowing me to come back. Actually, I'm coming back on the issue that I started out on my own, which was counting federal crimes. And I have to concur with everything that I've heard about the problem of federal courts, and I began with the numbers. And while numbers are not everything, they do tell a certain story. So I want to do 3 things quickly. One, talk a little bit about what the numbers are. 2, where are we going with the numbers? And 3, what is the significance of these numbers? When I testified on the November 13th, I mentioned the tremendous number of federal crimes and really the unknown number of federal regulatory offenses. After that, this task force asked the Congressional Research Service to conduct a count from 2008 to 2013, which is where my last count left off. They came up with the number of 403 new federal crimes. That's not counting regulatory offenses. That's just from the U.S. Code. And it's important to say that the counts from CRS, my count, and the Department of Justice counts have used fundamentally the same methodology, and that's important for consistency. What's significant, the second point about where we're going, it seems to me, is what this says about the average number of crimes and the total number of crimes. When I did the count in 2008, as of 2008, there were 4,450 crimes at least. CRS has noted that we have an additional 403 crimes. That brings us up at least to 4,853 crimes, almost 5,000 crimes. It means that essentially Congress is passing 500 new crimes a decade. Now, in the ABA task force that I served on back in the 90s, the notation was that since the Civil War, 40% of all federal crimes since the Civil War had been passed since 1970, from 1970 until about 1996. Well, when you add what's gone on since 1996, we're approaching 50% of all federal crimes ever enacted in this country have been enacted since 1970. And that was the beginning of the war on crime, which, you know, we haven't been winning that war too well. What does this mean for the future? Well, the rate of crimes appears possibly to be increasing. When I did my count, it was 56.5 crimes a year. CRS count shows 67 point something per year. Now, that number may be skewed because in 2008, Congress passed 195 crimes. What's the significance of all this? Well, if you talk to an assistant U.S. attorney, and I've debated a number of former assistant U.S. attorney, they will tell you that the numbers mean nothing. They don't use all of these crimes, and they're right. In a certain sense, they don't mean that much to the prosecutor or to the judges because there are only so many cases that you can bring in federal court. But where they are really important is in law enforcement. That we have plenty of law enforcement agencies out there that do searches and seizures and arrests in cases that never actually get even indictment, much less trial. Given the broad array of crimes, there's virtually nothing that you can't get a basis for probable cause on, which is the basis for arrest, search, and seizure. There's a lot of concern in this country, rightly, about privacy. But I think people ought to be focusing on the fact that surveillance is not just a matter of, quote, privacy, it's a matter of the police power. The federal government, which the Supreme Court has stated twice in recent years, has no general police power. In reality, de facto, it has complete police power, and we're going to see it in the surveillance. Now, people have been focusing on NSA, but think about drones. There is nothing a drone can't search, basically, because there's every possibility for coming up with the basis of it. And some of the federal agencies will conduct raids that will never result in an indictment, or if it does result in an indictment, will not result on those crimes. It is easy to come up with a RICO charge and a money laundering charge and go out and seize somebody's property. That's the reality of where the real power is. I think that this task force has done an amazing job of bipartisanship in coming together and identifying the problem. Now it is necessary for your colleagues in both houses to understand what the problem is. They're taking this tremendous power and dumping it in the executive branch with various agencies that in reality have their own agendas. I'm not saying they're bad agendas, but they're agendas. And there's really lack of control over what is happening out there in the field. Thank you for allowing me to make this statement.
Thank you, Dr. Baker. Mr. Benjamin?
Mr. Chairman and members of the task force, my name is Steve Benjamin, and I am the immediate past president of the National Association of Criminal Defense Lawyers, this country's preeminent bar association, advancing the goals of justice and due process for persons accused of crime. On behalf of NACDL, I commend the House Judiciary Committee for creating the Overcriminalization Task Force, and I congratulate the task force for its impressive work over the past year. I am especially grateful for the leadership and support of two members of my own congressional delegation, Judiciary Committee Chair Goodlatte and Task Force Ranking Member Scott, whose work on this critical issue demonstrates that the danger of overcriminalization transcends the traditional ideological divide. This problem is real, and it affects us all. The sheer number of federal offenses, 4,800 at last count, with 439 new enactments since 2008, competes only with our number of prisoners, a number greater than any nation on earth, as the most visible consequence of overcriminalization. But the consequences of this problem extend far beyond the number of those imprisoned or stigmatized. One such consequence is the difficulty of being a law-abiding citizen. Because criminal law is enforced by punishment, fairness and reason require adequate advance notice of conduct that is considered criminal. Adequate notice of prohibited conduct permits people to conform their conduct to the law, and at the same time justifies punishment when they cross a clearly drawn line. Notice is especially important in a legal system that presumes a knowledge of the law. Before punishing someone for breaking the law, we should at least ensure that the law is knowable. This is especially true where the conduct is not wrongful in itself and the offense requires no criminal intent. Criminal laws must be accessible not only to laypersons, but also to the lawyers whose job it is to identify those laws and advise their clients. The problem, however, is that the federal statutory crimes in the 10,000 to 300,000 federal regulations that can be enforced criminally are scattered throughout 51 titles of the Code and 50 chapters of the CFR. NACDL does not have a position on whether all criminal statutes should be organized into a single title of the Code. Common sense would dictate that most criminal provisions should reside in a single title unless clear evidence exists that a particular criminal provision belongs elsewhere. Fair notice goes beyond being able to locate criminal statutes within the Code. It includes clarity in drafting, precise definition, and specificity in scope. With rare exception, the government should not be permitted to punish a person without having to prove that she acted with a wrongful intent. And criminal laws should be understandable. When the average citizen cannot determine what constitutes unlawful activity in order to conform her conduct to the law, that is unfairness in its most basic form. Unfortunately, when legislating criminal offenses, Congress has failed to speak clearly and with specificity, has failed to determine the necessity of new criminal provisions, and has failed to assess whether targeted conduct is already prohibited or better addressed by state law. While the cause of these failures is not clear, the solutions are. Moving forward, Congress should approach new criminalization with caution and ensure that the drafting and review of all criminal statutes and regulations is done with deliberation, precision, and by those with specialized expertise. Given the unique qualifications of the Judiciary Committee and their counsel, which alone possess the special competence and broad perspective required to properly draft and design criminal laws, this congressional evaluation should always include Judiciary Committee consideration prior to passage. This practice could be guaranteed by changing congressional rules to require every bill that would add or modify criminal offenses or penalties to be subject to automatic sequential referral to the relevant Judiciary Committee. The members of this committee are far better suited to take on this critical role and to encourage other members to always seek Judiciary Committee review of any bills containing new or modified criminal offenses. Hopefully, such oversight would stem the tide of criminalization and result in clearer, more specific, understandable criminal offenses with meaningful criminal intent requirements, and would reduce the number of times criminal lawmaking authority would be delegated to unelected regulators. These comments are limited to the issues I was invited to address. The problems of overcriminalization are pervasive, and the measures necessary to reform go much further than reorganization or committee oversight. Further discussion, of course, is contained in my written testimony. I thank you for your bipartisan commitment to the task of ensuring that our nation's criminal laws are not themselves a threat to liberty. NACDL will continue to support and assist you however we can.
Thank you very much, Mr. Benjamin. The chair is going to reserve his questioning to the end of the questions, assuming we still have time and before the bell rings. And the chair at this time recognizes the gentleman from Alabama, Mr. Backus.
I thank the chair. I was looking at Mr. Benjamin's testimony, both your testimony, but I think we're to the point where we're ready to act, hopefully. We know the problem. It's been reinforced several times. We've gotten the message. And I think the key is, what do we do? And on page 9 of your testimony, Mr. Benjamin, you suggest at least 4 things I hear that and I know Congressman Scott has mentioned 1 or 2 of these. One is by changing congressional rules to require every bill that would add or modify criminal offenses or penalties be subject to automatic referral to the relevant judicial committee. And I think that's very important because, as you say, this is the committee with expertise. 2, enact a statutory law establishing a default criminal intent requirement to be read into any criminal offense that currently lacks one. 3, and it says this requirement should be protective enough to prevent unfair prosecutions and should apply retroactively to all or nearly all existing laws. And I actually know that's a radical idea, but I believe in that. And I think there ought to be something where you can go before a judge and present some evidence or before a board, particularly some of these environmental crimes. I have mentioned several cases of where people discovered hazardous waste on their property and reported it, but they couldn't afford to dispose of it fast enough. In a lot of these cases, I talked to a former congressman, Energy and Commerce was dealing with this, and he said we had a lot of these cases in the 80s and early 90s, and we kept trying to do something, but we couldn't figure out what to do, and maybe that's because it wasn't judiciary. The next thing, and I'm going to ask your reaction, on strict liability, your association urges strict liability not be imposed in a criminal law as a general matter. Where strict liability is deemed necessary, the body only employ it only after full deliberation and then only if explicit in the statute. I think that, we ought to say if it's not explicit in the statute, there's no strict liability. We could, and the 4th one is that I did not know this, but and I'll say this to members of the panel. The bottom of the page, he says, Supreme Court has cautioned against the imposition of strict liability in criminal law and has stated that all but minor penalties may be constitutionally impermissible without any intent requirement. We've said several times in our deliberations, and witnesses have, that without an intent requirement, I can see a minor fine, but when you're talking about putting someone in jail for a year and a day, that's pretty scary. But I would just say, I would ask both of you to give us 5 or 6 specific statutes that we can do, or your associations, and even, draft some just as a model, and we could look at them. And I think that would be particularly helpful. I really appreciate your testimony, and Dr. Baker, you've been here before. This to me is such an important thing, because I think we have seen travesties of justice. We've seen people with no criminal intent. And if anything else, the government can use that power to force them to do things just with the threat. You know, they don't have to get a conviction. They can just, and you could really, it could be used in a way that we see some countries around the world that use the judicial process simply to put people in jail that stand in their way of whatever their goal is. And I hate that on certain cases people with agendas have maybe done that here. That's a shame, because that's not America. That's not what our constitutional forefathers envisioned. My time is up. So.
Time of the gentleman has expired. The gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Dr. Baker, what problems could occur if we defer to states for prosecution of virtually all cases that do not have a bona fide federal nexus?
Well, even today, most cases, the overwhelming number of cases, are still prosecuted at the state level. It's more or less on a selective basis that prosecutors pick cases. Sometimes there are conflicts between local law enforcement people in terms of where the jurisdiction is, fighting over certain cases, high-profile cases. Other times it's cooperation based on money. When I was prosecuting in New Orleans, we had longer sentences than the federal, if you can believe that. And so all of the federal drug cases, the federal agents would steer into our courts because of the longer sentences. Some states, the drug people will steer the case still into state court if there is a tougher provision on search and seizure. So law enforcement people are very practical, and so to give a general answer to it, you'd have to be specific place by place. I'm not exactly sure what you're trying to, would it overwhelm the state? Is that what you're talking about?
No, we're just, as a general matter, we ought to defer to the states. One of the previous witnesses said, in ascertaining, when you go through the list of things that you ought to consider, the differential in penalties was not on their list of things that were legitimate to consider. Do you agree with that?
No.
That you can pick and choose your jurisdiction based on the
Absolutely, we did it.
well, I'm not saying, well, yeah, you did it.
Yeah, I mean, we did it. The question was
and we did it in Richmond, and people brag about the fact that Project Exile worked.
I wrote against, I have an article against Project Exile.
Good.
I'll show it to you.
Well, without pointing out that in Richmond the crime rate went down because it had Project Exile, but in other cities in Virginia that didn't have Project Exile, the crime rate went down more.
Exactly, I pointed out in my article.
Mr. Benjamin, you mentioned notice. How do you get notice? If you have mens rea, obviously you had notice because you had criminal intent. How else would you get notice out there so that people know that they're committing a crime?
Well, you make the laws accessible. Now if someone wants to determine in advance whether their proposed conduct is criminal, they've got to hire a lawyer to answer that question, and then the lawyer has got to find the statute within the 51 titles of the code. It's nearly an impossible task, and that's why we always hedge our bets. Few lawyers are going to say, you can do that. It's because the law permits such uncertainty. It is so ambiguously written that it's impossible to know, even by lawyers, whether proposed conduct is truly lawful or unlawful.
Is that why the rule of lenity is so important?
That's exactly why the rule of lenity is so important.
Can you say a word about the overlapping crimes in state and federal and what it does for the so-called trial penalty?
I certainly can. The trial penalty is the penalty for going to trial, meaning that if you let me back up, because I think it is a unique and cherished American value, consistent with freedom and liberty, that if the government accuses us of a crime and threatens to take away our freedom, we have that right to stand up to the government and not only deny it, but make them prove it, to say, oh yeah, prove it. But we have completely lost that right, because if we go to trial, either because we want to make the government prove their allegation, or we want to challenge the constitutionality of a dubious statute, or because we are innocent, we can no longer do that. Because if we lose our bid to challenge the government, then we face staggering mandatory minimum sentences that can be stacked by the prosecution to beat us into guilty pleas. That's not how our system was designed.
Are there problems in consolidating all of our codes into Title 18, or would it be better to have them spread all around where the subject matter crime goes with the subject matter, like the agriculture code?
Well, first of all, when the proposed federal criminal code back in the 80s came before the Judiciary Committee, the real problem was in organizing the code, people didn't pay attention to all of the many provisions. In one sense, it was a code, but in another sense, the federal government should not have a code, because a code is a comprehensive statement of criminal law. And if you believe, as I do constitutionally, that Congress has only limited powers and has to justify it on particular enumerated powers, then the idea of a comprehensive criminal code is very difficult to create without, in effect, expanding federal power. My main concern about a general code like that would, even with an attempt to limit federal power, it would de facto end up expanding federal power.
The gentleman's time has expired. The gentleman from Michigan, Mr. Conyers.
Thank you, Mr. Chairman. I want to thank both of you gentlemen, and this is our 10th hearing, and both of you have been here before, so this is a good place and a good point to begin with is how do you see the cumulative effect and impressions and understanding that we've gleaned out of these 10 hearings this year and last year? Dr. Baker, why don't you start us off on that?
Well, if I compare back to federal criminal trials that I sat back through when I was a law clerk and federal trials today, the biggest thing that strikes me is the imbalance of power and how the power has shifted so dramatically towards federal law enforcement to the point where not everyone, but there's a certain arrogance that pervades the prosecutors. And it goes with the territory, unfortunately. When you give anybody too much power, they're going to use it. And I don't mean that they're using it for what they perceive to be bad things. They believe that what they're doing is the right thing. Of course, when they then resign and become criminal defense attorneys, they get a different perspective. And they realize, well, maybe we were a little too aggressive. And I can tell you that I have been on panels with former AUSAs, and they have said that now that they're on the defense side. The reality is there are three perspectives: the prosecutor, the defense, and the judge or jury. And they're not the same perspectives. And there has to be a balance between the two sides. And I think at this point that the balance is too much in favor of federal prosecution.
But still, state crimes are far more numerous than are federal.
They do, but here's the difference. You know from Detroit, and I can tell you from New Orleans, people trying to prosecute and arrest, they are running around trying simply to deal with the violent crimes that they have to. Very few prosecutors in major cities have time to go looking for things. They can't find what's already been done. That's not the case in federal court. In federal court, you convene a grand jury and you go out looking. You got the defendant, potential target, and then you figure out, well, what has this person, what can we nail him on? That's not the way local prosecutors work.
Attorney Benjamin, would you weigh in on this discussion, please?
I agree absolutely with Dr. Baker that the most striking facet of the current state of the criminal justice system, and the biggest, the most dramatic change from when I first began 35 years ago to defend criminal cases is the overbalance of power. Federal criminal defense now is all about negotiating a resolution.
Sentence. That's all it is.
That's all it is. It's no longer about guilt or innocence. Guilt is presumed, at least by the prosecution. And they have the tools available to compel the guilty plea so that that's not even a question. It's all about snitching out, cooperating, doing whatever you have to get the leniency, the fair treatment that you seek.
So what then do we bring to our full Judiciary Committee and the House of Representatives in terms of these 10 hearings that we've had this year and last year? I mean, what can we take? And I want to commend the chairman and ranking member, Sensenbrenner and Scott, for having put this together as they have. But where do we go from here?
I think the immediate thing is reform of the mens rea problem. The immediate Band-Aid that is necessary is a default rule of mens rea where none appear in criminal statutes, and a rule of construction that applies a mens rea to all, at least to all material elements.
A single mens rea standard? Or
No, uniform mens rea standards.
Okay.
Clearly defined across the board.
Mm-hmm. And what would you add, Dr. Baker?
Well, I would agree with that. I've been involved a little bit in trying to draft that statute, and I can tell you it's not an easy statute to draft because of the way, first of all, the federal crimes are drafted and how differently they are. I would add to those two things, which I endorse, clear definitions of what's a crime, what's a felony, what's a misdemeanor. And a way to deal with the strict liability is simply to say non-criminal offense. So that and this is in the model penal code, but not many states adopted it. I mentioned it in earlier testimony. You have a provision for non-criminal offenses, and that strict liability is limited to those. So if you think they need to be prosecuted, fine, but the stigma of crime is not on there.
Time of the gentleman has expired. Gentleman from Georgia, Mr. Johnson.
Yes, as I listened through to the testimony and did a little reading, I was impressed with the fact that Dr. Baker, in your paper, you cite statistics showing that in 1983 it was estimated that there were 3,000 or so criminal offenses in the code. And in 1998, you cited DOJ figures of 3,300 as of 1998.
Well, no, those were two different studies, and it's noted in there. One was by DOJ, the first one. The other one involved the same person, but there were different methodologies used, and that's why the different numbers.
I see. But that does not indicate that there was no growth in the number of
oh, there was
offenses.
growth, but actually...
May or may not have been 300.
No, it's more. It was more than that.
Well, okay, all right. Well, so that's a modest assessment, 3,300 as of 98. That was 300 more than in 1983. And then between 1998 and 2008, that 10-year period saw a rise to 4,450, according to your.
The 1998 figure, which I explain in there, is not a reliable figure because it did not follow the methodology.
So you think it was higher?
It was much higher.
Okay.
The DOJ methodology, which I used and which has been by email told to me by the person who conducted it, that I used the same methodology that DOJ did. We explained that methodology to CRS, and CRS basically followed that. But what happened in the 1998, they did not break particular statutes down into the various crimes within one statute. They simply counted the statutes.
I see. Okay. So, and between 2008 and 2013, you cite an additional 403.
Well, that's a CRS report.
Okay.
And the skewed year is 2008 with 195 crimes.
Well, it puts us, according to the reports, to close to 5,000 offenses. And it looks like from 1983 through 2008 was an explosion also in the number of human beings we have imprisoned in this country. And then at the same time, we've had the growth of what I'll say the conservative movement in the country, which has called for less government, less taxes, which when you put on top of that the fact that you're needing more prisons, more jail space and more prisons, you've seen a growth in the private prison industry. And in fact, 1983, 3,000, 2013, close to 5,000. 1984, it should be noted, is when the Corrections Corporation of America, which is the largest private prison for-profit corporation, that's the year that was founded, 1984. And since that time, they have experienced exponential growth, and to the point where they, along with, there's another big one, I forget the name, GPC or something like that, but those corporations are publicly held corporations selling stock on Wall Street. What connection do you see between the growth of the private prison industry and the number of and the amount of contributions that those companies make to legislators, including on the federal level, and the growth in the prison industry? The growth in the prison industry, the growth in lobbying, and the growth in statutes putting people in prison. What connection do you see?
Well, I can draw a connection between the growth and certain things. I can't between all of them. I actually represented at one point a sheriff in Louisiana who built the largest public prison system, and the whole thing was funded by federal dollars. He went in the business of taking in federal prisoners because the federal rate was much higher than the state rate. There is a definite connection in terms of the growth of prisons, but on the conservative side, especially in Texas and in Louisiana, they are understanding that this is bankrupting the states. And so now you have some conservatives flipping and calling for a reduction even in state criminal penalties and state prison sentences because they realize that the growth of it, the expense, is unsustainable.
Well, I tell you,
Mr.
Chairman,
Gentleman has expired.
Mr. Chairman, could I make just one last statement? I would imagine that we will now see a rise in lobbying costs that are incurred by the private prison industry. Thank you, Mr. Chairman.
Okay, the gentleman from New York, Mr. Jeffries.
Thank you, Mr. Chairman, and let me thank the witnesses for your presence here today and your continued contributions to the efforts of this panel. Attorney Benjamin, you mentioned something that was very troubling, and Dr. Baker, you agreed with it, the notion that federal criminal defense has simply become negotiation efforts toward resolution. Right. And that just seems fundamentally inconsistent with the notions that have always served to undergird our criminal justice system, the presumption of innocence. If there's going to be a presumption of innocence, it seems to me it cannot be the case that once someone is being investigated and or is indicted by our government, that the only real option available to someone who in theory should be presumed innocent is to negotiate the most favorable resolution, which ultimately will likely result in some form of sanction and or jail time.
Right.
And so the question becomes, how do we unpack this dynamic in a way that allows this task force, the House, this Congress to make a meaningful impact? And I would suggest, and I would like to get the observations of both of you, that it seems to me that there's got to be some way to rein in the inappropriate exercise of prosecutorial decision-making. You referenced the term arrogance that exists perhaps amongst some prosecutors, and I believe the majority are operating in good faith, though I may not agree with the decisions that they make. But who, as it currently exists right now, has the capacity to oversee prosecutorial behavior and or decision-making, and what consequences are there when inappropriate public policy decisions are being made? Start with Attorney Benjamin, and we'll go to Dr. Baker.
Well, the power of oversight and the power to rein in federal prosecutors resides in either DOJ and the Attorney General or the U.S. Attorney for a given district. The reality, however, is that rarely will these individuals want to interfere with the career prosecutors who have been doing this all their lives and are on the line. And so the answer is to take a look at the tools that are being used to produce this result. And I think that the biggest problem is the existence and the expansion of the use of mandatory minimum sentences. That is what gives the unfathomable power to federal prosecutors. Because they can, in their charging decisions, threaten 10, 20, 30 lifetime mandatory sentences. That takes the judge completely out of it. If somebody is convicted, what we will say to our clients is, yes, sure, I understand you're innocent, and maybe you have a triable case. But if you lose, you will get a life sentence.
Right. Now, Dr. Baker, I appreciate that observation. Dr. Baker, I want you to respond, but also I want to add this observation. Currently, federal prosecutors have absolute immunity, as I understand it.
As long as they're, well,
in the context of their
prosecution, as long as they're not getting out of prosecution.
Right.
Sometimes they get involved in the investigation.
Okay. In the context of the prosecution, they've got absolute immunity. Law enforcement's got qualified immunity, as I understand it. Is that something that we should explore?
I guess as a former prosecutor, I liked absolute immunity when I had it. I haven't given it enough thought. I think that there is a reason for immunity, whether it should be qualified and more like law enforcement. The assumption is that a prosecutor is under the control to some extent of a judge in a way that law enforcement is not.
Right, that's the assumption, but I think the testimony that we've received is that that's no longer the case, that even Article III federal judges to some degree have lost control. So I'm trying to figure out—
But the real responsibility is with the president and then the attorney general.
Right.
The political reality is that, I don't care what party you're talking about, that it depends on the particular U.S. attorney and how he or she got appointed and whether they've got a senator protecting them. That's really what it comes down to.
One last observation. The problem that we confront is both to rectify the damage that's been done, but also figure out how moving forward we can prevent a return to just a cycle of endless criminal statutes being added to the books. And it's often the case that elected officials react to the passions of the public. In fact, that's the kind of constitutional charge of the House of Representatives. Right. But in the criminal context, when you respond to the passions of the public, particularly as it relates to a particularly heinous crime, that results in perhaps doing things that in retrospect aren't in our best interest. And I would just encourage all of us, certainly those who are contributing to this effort, to think about that dynamic as we move forward.
Thank you very much. The time of the gentleman has expired. Let me recognize myself for 5 minutes to wrap up, and this will be more of comments looking at the last year and what we've been able to discover. First of all, I want to thank the witnesses for appearing. The two authorizations of this task force, I think, have only scratched the surface of what needs to be done. Because literally the Congress and a lot of the agencies have been putting more and more layers on the onion, and we're beginning to start to peel off the ones on the outside. And that just asks more questions. You know, looking at how we got to this, and I think in order to stop this from getting worse, we do have to very vigorously pursue a change in House rules. And some of the lapses that have allowed other committees that really don't know very much about the criminal law to make criminal law is the fact that the Judiciary Committee has not been very vigorous in asserting its jurisdiction, and that's got to stop. The parliamentarians have always said that once we lose jurisdiction, because we didn't claim it, then it's much harder to get it back, and they'll just forget about us when they refer bills. So exchanges of letters for further legislation, I think, is necessary. We are going to need help in developing a default mens rea statute. Default means when there is not a specific criminal intent in a statute, there will be one. If there is a specific criminal intent, the default statute would not apply. And at least you have to have a criminal intent as one of the elements in terms of obtaining an indictment or a conviction. Now, in order to get at the proliferation of criminal penalties, some of them are statutory, some of them are done administratively. I would like to see the Judiciary Committee draft and get passed and enacted into law a sunset provision of all administrative criminal penalties. It should be a fairly long sunset, and the committee, I think, can then ask each agency to come in and justify which of those criminal penalties they wish to have continued on the statute books and why. And if they can't justify that in order to get a reenactment through the Congress, then those administrative penalties would simply vanish and we wouldn't have to worry about them anymore. Now, I think a way to start in on the anti-duplication provisions of the code is to start scrubbing the bill that I've introduced in this Congress and the two preceding Congresses, which was designed to reorganize the code and to at least put some sense in it so that people could look and see what activities were criminal in nature without having to go to a lawyer who can never give them a definitive answer, because no matter how hard the lawyer tries, they'll never be able to find what statutes are involved in that. And I know that in the few days that we have left in this Congress, none of this is going to be accomplished. However, I would hope that as we prepare to start the next Congress, we will be able to, in a bipartisan manner, which has certainly permeated this particular task force, to pick up each of these areas to figure out what to do and to figure out what we can get enacted into law. And I think the American public, while they will not see an immediate change in how we approach criminal issues, that there will be something that will be long-term that will deal with many of the results of our over-criminalization. So again, I want to thank the witnesses. I want to thank the members of this task force for putting in a lot of time and doing a lot of good work. Remember, we've got probably the first two layers off the onion, but there are many more layers that we've got to go. So without objection, this subcommittee hearing is adjourned.